say you wanted a record or no record?
Record, please.
Okay. Let's go on the record on cause number DC 213772, Ervins versus Williams. Counsel, make your appearances.
Victor Rodriguez for the plaintiff, LaDiamond Ervins.
And Bryson Matthews on behalf of both defendants, Henry Williams and Francis Trans Incorporated, doing business as J. Friend Cargo.
All right, let's proceed.
Yes, Your Honor. We are here on defendant's motion for leave to designate Demetrius Ervins as a responsible third party in this case. This motion for leave is filed pursuant to section 33.004 of the Texas Civil Practice and Remedies Code. It's a fairly straightforward set of facts. On the date of this accident, LaDiamond Ervins, the plaintiff, was an unlicensed driver. The owner of the vehicle was Demetrius Ervins, and it's our allegation that Demetrius Ervins in this case is also allegedly responsible for this accident for negligently entrusting her vehicle to a driver who she knew or should have known was unlicensed at the time of this accident. Pursuant to section 33.004, it states that the motion shall be granted unless an objection is filed. And even if an objection is filed, the court still must grant the motion unless it is established that the defendant did not plead sufficient facts concerning the alleged responsibility of the person to satisfy pleading requirements in Texas. Today, I believe that those requirements have been met. There are more than enough sufficient facts pled by defendants concerning the alleged responsibility of Demetrius Ervins in this case, and it's our position that the motion should be granted. Jumping forward just a little bit, it's defendant's position that a red herring argument is being presented by the plaintiff in this case. At this stage of the proceeding, there's no one's requesting apportionment of fault at this case, and all of plaintiff's arguments and all of their cases cited have only to do with apportionment of fault. And it's also worth noting that in all of those cases, that decision was made at the time of trial, whether they were arguing about the jury charge or issues at trial, not at the responsible third party stage, Your Honor.
Okay. Response?
And essentially that is our objection to this request for leave of court is because negligent entrustment is a derivative claim, meaning there must be negligence of Miss LaDiamond Ervins for there to be any negligence for negligent entrustment on her mother. We've made this objection accordingly. Essentially, we don't dispute the facts of driver, owner, no dispute there, Your Honor.
Let me ask you this. Are there any cases, I've never had anyone try to designate a responsible third party for a negligent entruster. I'm not saying that it's not allowed. I just have never seen anyone do it. Are there any cases that say, hey, you can't do this for somebody who's an alleged negligent entruster, or kind of what?
And that was part of what we cited to, Your Honor, was that when you look at the responsible third party definition and you're dealing with someone, there's a case we cited to, it's out of the Corpus Christi Court of Appeals. It's Helm versus Kingston. It says, consequently, a party whose liability is solely derivative or vicarious in nature does not meet the definition of a responsible third party, as it is only liable for someone else's acts and thus stands in the same position as that other person. So yes, having them on the charge would be problematic given, it's derivative as opposed to it being more of an independent cause of action that did not rely on the underlying negligence.
Okay, how do you distinguish that case?
Yes, Your Honor. As far as the defendants are concerned, there's at least one case that we cited in our reply, Bedford versus Moore, that stands for the proposition that you can include a negligent entrustor as far as the apportionment of fault question goes as well. As to the specific case cited by plaintiff's counsel, Mr. Rodriguez, we would defer back to the specific wording of the statute itself. In this case, there is no arguments that we did not plead sufficient facts concerning the alleged responsibility in this case, which is really the only argument provided by statute against granting a motion for leave in this instance, Your Honor.
Okay. All right. The court will go ahead and can you share screen, Mr. Rodriguez, the case that you're relying on?
Yes, Your Honor. Can you give me?
I need to enable it. I apologize.
No problem. It's right here, the Helm versus Kingston. Is that large enough for Your Honor, or do I need to zoom in more?
Let me see. Okay. And you have it, and do you have an actual copy of that case?
Not at this moment.
Okay. Do you have a copy of the case you're relying on, Mr. Matthews?
Not a copy, but I can obtain one.
Okay. Okay. Well, and you say how again do you distinguish that case?
Your Honor, the two ways that defendants would distinguish that case would be one, there's a case at Bedford versus Moore, which is out of the Fort Worth Court of Appeals, that has come out on the opposite side of the issue that plaintiff puts forth, and basically says that it is entirely proper to submit the negligent entrustor in the apportionment of fault issue that's being argued by the plaintiff, and deferring back to the specific language of section 33004, there have been nowhere in the objection filed by the plaintiffs anything disputing our pleadings concerning the alleged responsibility of Demetrius Ervins that we've alleged in this case. There has been nothing met as far as plaintiff's burden to.
So is it fair to say there's kind of a split in jurisdiction at this point?
I would say that that's fair as far as the actual apportionment of fault issue, which again, it's defendant's position that we are not at that stage in this case. All of the cases cited by both sides, I believe it'd be fair to say, are handling that issue at the time of trial, whether it's the jury charge or what other stage they're arguing, not at the responsible third party stage.
Okay, well, let's do this. Let's just hold off until the time of trial on this, and we'll make a determination closer to trial. And if there's any more cases that come up, right, it seems like there's kind of a split in jurisdiction, and let's just kind of figure it out then. How does that sound?
I don't see any issue with that. Just for clarification purposes, there's the specific timelines that we deal with also with this being filed and decided 60 days prior to trial. I'm assuming
I have to
this would
decide
kind
it
of
60
dispense
days.
with that.
Okay, your position is I need to decide it 60 days before trial.
Well, no, that's just the language in the statute. I'm assuming that this would dispense with that kind of time frame if we're going to defer it till the time of trial. And I just wanted to make sure I was on the same page.
I mean, how do you feel about this, Mr. Rodriguez? Do you want me to go ahead and make a decision now?
I'm okay if the court feels it's appropriate to defer till that time period.
Okay. Yeah, who knows when we'll ever get to trial on this anyway, just with COVID. Have you all been to mediation on this?
Not yet.
Okay.
But we are diligently working both sides. Both sides are diligently working to see if we can, and if we cannot, it's only because we did our darndest.
Okay. I don't know if you guys heard they've delayed trials again because of COVID. So, or
I saw that just.
I'm sorry.
I saw that just came out today.
Yeah. So I'm not sure how long that's going to be for or what, but we're already so backed up that I don't know. Honestly don't know what, anyway, we'll see what happens. All right, guys. Well, thank you so much. And if you do feel like you need me to make a decision on this closer to trial, feel free to reach out again. But for now, I'm just going to kind of delay and kind of see how it goes. And you said, and hopefully you guys can get it worked out.
Okay. Thank you, Your Honor.
Thank you, guys.
Thanks. Bye.
Okay. Our next hearing is at 1:45. It is the motion to strike White Smith versus Lewis. Are both sides here for that?
Yes, Your Honor.
Yes, Your Honor. Marcus Marsden on behalf of the defendant.
Y'all want a record on this?
Plaintiff does not, Your Honor.
That's fine, Your Honor.
Let's proceed.
Good afternoon, Judge. This is a motion to strike the counter affidavit of Robert Nocerini. Dr. Nocerini is a local anesthesiologist. He has basically contested the bills, if you would, for two medical providers of my client, Vital Pain Care and SOAR Institute, which is an orthopedic group. He agrees that the services rendered by those two providers to my client were medically necessary. The basis for the plaintiff's motion to strike essentially is that Dr. Nocerini has selected as his sole basis this database called Context Arabic for Healthcare. And within that, he's gone in and extracted basically two things. One is he's seized on this idea of the 80th percentile being what he calls reasonable for charges for a service in the geographic market. And he's also made the comment that major payors in some state governments, along with the Texas Department of Insurance, recognize charges at these percentiles. Our position, and we fully acknowledge the fact that, May's decision in Allstate has changed the waterfront in this whole thing. However, I don't think it literally did away with affidavits, and certainly doesn't allow the defense to come in and just throw out anything that might stick on the wall as a basis for defeating it. There is nothing in Dr. Nocerini's affidavit that shows why he selected or why this Context for Healthcare database is a proper authority for what he's doing. Nothing. He just says, I'm going to use this. Likewise, there's nothing within it once he goes into that database and picks up 80%. There's nothing here that says why that's appropriate as a marker for a fair and reasonable charge. And then similarly with his position that some major payors, the Department of Insurance for Texas, how he pegs that again without any explanation. He just says it as if it's so. I think to offset that, the comment we made in our motion to strike is that the American Medical Association has adopted a policy that says a physician's fees are reasonable when they're the usual fee and what is within the range of usual fees currently charged by physicians of similar training and experience within the same geographic area. That to me is where we should be focusing. Instead, you have nothing in there about Dr. Nocerini commenting on whether the charges by these two providers were their usual charges. Likewise, there's nothing in there where he considers the range of usual fees currently being charged by physicians of similar training in the same geographic area. There's no language about that. By referencing what he believes are other major payors, state governments, and the Texas Department of Insurance to be reasonable, clearly that's not the position of the AMA, is what is a fair and reasonable charge. So essentially, if we cut to the chase, Judge, what we believe is we've got an MD coming in, riding on the fact that he's an MD and simply making these statements all of which are conclusory. It does not give, even following the Allstate case, the plaintiff fair notice of exactly what it is he believes these charges were not fair. He's simply throwing this stuff out. And if we continue down this track, Judge, then again, like I said in the beginning, I don't see how any affidavit will ever stand up if they're allowed to be this vague. And just because we've got a doctor, an anesthesiologist at that, he's allowed to come in and make those kind of statements. So based upon that, we don't think it's fair notice, and we would ask the court to strike his counter affidavit.
Response?
Your Honor, as the court's, excuse me, well aware, under 18.001, the affidavit is required to give reasonable notice of the basis upon which the defendant intends to controvert the claim reflected in the initial affidavit. If you look at the affidavit of Dr. Noserini, I mean, it's really nothing more than just, quite frankly, the plaintiff just disagrees with his opinions, because he gives ample support for his opinions. He specifically provides and describes the context for Healthcare Inc. and why he used that, and he explains that what that database is, that database is over 1 billion actual submitted claims, and basically represents more than 70% of all claims submitted in the United States. The affidavit in his report goes on to provide an opinion that it's why he chose the 75 to 80 percentile. And he even specifically says, for a specific geographic market, and he opines to this specific geographic market. And so I don't see how the plaintiffs can argue that they're not provided reasonable notice or the basis for Dr. Noserini's opinion. They may not like it. And clearly
So are you relying at all on the Supreme Court's decision in Enright Allstate, or do you think that opinion doesn't really apply here?
On this motion to strike, I don't think it applies, because they're not contesting his, that he's qualified. They're just saying that we didn't provide the facts of his affidavit, don't provide adequate notice. But I mean, he goes in addition to specifically outlining the basis for his opinion, then he goes in and specifically addresses by date and by service what he believes the reasonable fee to be. So there's not any question, if you read his affidavit and his report, that he's provided reasonable notice as to what he intends to testify to, and the basis upon which he's going to contest the charges by these two healthcare providers.
Okay, response?
Judge, obviously, your question to defense counsel, I do believe Allstate applies here. And I think the issue is whether we're being given fair notice. And again, I don't read his affidavit as defense counsel does. What I see is this anesthesiologist coming in with this obtuse website he found somewhere, talking about charges, billion charges. I don't think that's what the American Medical Association talked about. I think what you'd prefer to have seen, that he had made a survey or analysis of the charges by physicians of similar training in the same geographical area. I don't see that. I likewise don't believe that when he throws this in about the fact that major payors in some state governments, along with Texas Department of Insurance, that totally goes contrary to what the AMA talks about in terms of using government type things like that. So no, I don't think the issue is fair notice, and I don't think he's given fair notice as to how he picked up this database and then how he went into that database and picked out established 80%. I don't see it. So clearly we disagree on that, and I believe it should be struck.
It's really hard to tell after In re Allstate how any counter affidavit can be struck, but I'll go ahead, I guess, and strike it, and we'll just kind of see how it goes. I don't think it provides fair notice. It's one I would have clearly struck before In re Allstate. I think In re Allstate does significantly broaden the field, and so of what can be struck, unfortunately. I think it comes at the worst possible time for the courts that In re Allstate was decided, but anyway, that's what we're going to do.
I could beg the
Your Honor,
court's
just-
indulgence and bring up one other matter.
Well, hold on just a second, Mr. Mills. Just to make sure that, obviously, I'm assuming, and you know what that does, gets us in trouble, but I mean, obviously, even though the affidavit is struck, we'll still be able to bring Dr. Noserini testify live at trial as to.
Absolutely. Nothing. I think one of the issues in In re Allstate is you had I'm not criticizing the judge, but the judge's decision was awfully broad. And I've seen it, I've heard some judges here locally may do this. I've never done it. Is that by striking an affidavit does not mean necessarily that the witness is struck. It's two separate inquiries, a Daubert inquiry versus this inquiry. So if you want to call the doctor live and the doctor is not struck for Daubert reasons, then the doctor can testify.
Okay, that's what I thought. I just wanted to clarify. I'm sorry, Mr. Mills. Go
No, that's
ahead.
okay. Judge, if I could raise one other issue. The history of this is I filed the motion to strike. I was not able to get it heard. I then contacted defense counsel and said, I'd like to take Dr. Noserini's deposition. I was beyond the discovery deadline. Defense counsel objected. I immediately filed a motion to continue the case with the court. That motion was set on the motion to continue today at 1:30. Last Friday, we got notice at the court that the case had been reset to July 12th. What I wanted to put before the court is that part of it. I'd like the court to consider my request that the discovery deadline be extended to allow me to go in and take Dr. Noserini's deposition, particularly given the fact that defense counsel will be calling him live.
I don't have a problem with that, Mr. Marsden.
My only objection to that, Your Honor, is we're operating under an agreed scheduling order where the discovery deadline has passed, and plaintiff has had notice of Dr. Noserini's affidavit and report since February of last year. And on the eve of trial, all of a sudden now he wants to take his deposition when he had 6 or 8 or 10 months to do it. That's our only objection to the extending the discovery deadline date, Your Honor.
Let me just say this. This is not a ruling. I'm just going to tell you what I've done. And pretty much I try to be as consistent as I can, especially in personal injury cases where you see the same issue over and over again, is in a situation like this, I can't imagine, Mr. Mills, you would, if you're going to, seek court guidance on this, if you seek leave to take discovery beyond discovery deadline and take this deposition, I cannot imagine a situation unless you just delay it for a long time and wait that I wouldn't allow you to do that. That being said, I'm not going to sua sponte do it. And so you may have to file a motion if Mr. Marsden doesn't agree. Now, Mr. Marsden, I will tell you that unless he delays this until, 5 months from now, I cannot imagine a situation where I wouldn't allow him to do that. So, especially given that there's a continuance in the case, and I thought it was an agreed continuance, was it not?
No, Your Honor. I think that the court was just getting ahead of COVID. We got a notice from your court that the case had been continued and they were going to move my motion to strike. Instead of hearing the motion to continue today at 1:30, the court would now hear the motion to strike.
And I think that, and we're trying to get some deposition dates for Dr. Noserini, so they're already being proactive in that regard. We just wanted a little guidance from the court on the discovery deadline period expiring. So I think we're good to go.
All right. just get me an order on that, Mr. Mills, and we'll go from there.
Thank you.
Certainly. Thank you, Judge.
Okay, our next hearing, I believe, is the 145 hearing. And that is anyone here on the 145 hearing?
Your Honor, Rick Hannigan with Haynes and Boone on behalf of Central Living Trust, which I believe is the 145.
And Courtney Morris here on behalf of the City of University Park for the writ hearing as well.
Yeah, I took a look at this. It's interesting. I actually tried one of these cases when I was in private practice where we were appealing a decision from the City of Dallas. My understanding is that we would have to have some type of trial on this. This is set for a 15-minute hearing. I'm not sure how I would hear this right now. Are you anticipating that this would be heard like right now as a trial, or how are you? Give me kind of an understanding of what.
No, Your Honor, essentially just the issuance of the writ is essentially like service of process. So all we're doing is the writ just asked the UP Board of Adjustment to submit its record and documentation setting forth the materials that provide the grounds for its decision. And
Okay.
Under the local government code, we've got to give them at least 10 days to do that. Ms. Morris can probably tell you how much time, would be reasonable for them to do that. And then once that happens, it's essentially it's a legal issue. It might be summary judgment. There might need to be a trial, but this is just essentially a perfunctory writ to require the city's Board of Adjustment to return its materials justifying its decision.
Ms.
Your Honor,
Morris?
yes, we agree. The city does not oppose the writ. The petitioner filed the appeal timely, filed the writ timely. We have no problem with that. The only request we would make due to the current uptick in COVID cases, and our department lost 3 employees last week. We'd like a little additional time to be able to get the record in. If we could have 30 days, I think we could make that happen.
That's fine with us, Your Honor.
Okay.
And do you want, Ms. Morris, do you want to have a formal writ executed, or do you just, our agreement on the 30 days, is that sufficient?
Our agreement on the 30 days is sufficient.
Why don't we put that on the record just in abundance of caution? Mr. Hannigan, I'm sorry, is it Hannigan or
Hannigan with A?
Hannigan. Tony, are you ready? Okay. Mr. Hannigan, go ahead and announce the cause number and case name.
Yes, Rick Hannigan on behalf of Central Living Trust. It's cause number DC 21-17275. Central Living Trust petitioner versus City of University Park Board of Adjustment. It's on Central Living Trust, a verified petition for writ of certiorari, and we're asking for the issuance of the writ. The parties have agreed that no writ needs to be executed, but that the city will have 30 days to return documentation required under local government code 211.011 to the court.
Is that agreed to, Ms. Morris?
Yes, Your Honor. Yes, Your Honor, that's agreed to.
All right. It's a Rule 11 agreement, so I don't need to order anything. We just have a record of it now. Anything else, guys?
That will do it.
I guess my one question is, big picture here, do we need to set this case for trial at this point, or do we need to set it for a hearing, or kind of what do we need to do at this point with this case?
Your Honor, to me, and I don't know that Ms. Morris has had a long time to study this, this involves the interpretation of one of the city's ordinances as to whether the property in question qualifies as a double frontage lot under the definition in the ordinance. It's our belief, based on the record, and there was a record taken at the Board of Adjustment hearing, that the court will be able to resolve this by summary judgment. And we plan to file one, in the near future. If that can't happen, then there would need to be a trial, but I think the trial would be a half a day at the most.
When do
It's
you
a
want
pretty
us to?
simple issue.
When do you want us to? So we need to set it for trial. It sounds like at some point after you do the summary judgment. So when do you want to set this for trial?
I could do as early. I mean, summary judgment. Let's see. We got 30 days. I would think we could do it in June, July, August.
Ms. Morris?
I believe that time frame is correct. Yes.
Okay. Rhonda, go ahead and set this for trial. Who knows? We're so backed up right now. Who knows how this will go? But let's go ahead and set this for trial on August 2nd. Did you get that, Rhonda? Okay. Okay. Anything else, guys?
That will do it. Thanks for your time, Your Honor.
All right. Thank you. You guys be
Thank
safe.
you.
All right, you too.
Okay. I just wanted, the next case we have is just a quick status conference on the Canterbury case. Are all parties here for that?
Your Honor, before you proceed with that, I received notice for another 145 hearing in Granger versus Pilot, but I seem to be the only attorney involved in that case here today. So it's not my motion. So unless you see something on your docket noting that it's supposed to happen.
We have the one we just had. We have at 2:00. We have Katiba versus Gonzalez. Is that it?
No, it's Granger versus PPS.
I don't see that there's ever been sent anything. That's not been set for hearing at any point in this court today.
Okay. Well, then I'll reach out to the attorney who sent me this notice of hearing, and Your Honor, if I may be excused.
Yeah, come back on the Zoom if you determine there needs to be something done, but no, we don't have anything set right now.
Thank you, Your Honor.
All right, thank you. Bye-bye. All right, the status conference, I just wanted to kind of, as opposed to sending you guys a long fax or something that may be misinterpreted, I wanted to just let you know what I'd like you guys to do on this. Is that there was a request for findings of fact and conclusions of law. Mr. McCafferty, I'd like you to go ahead and try to prepare that, but I want you to work with the Hayes on this because they won on certain points, you won on certain points. So put together a proposed findings, run it by then. If there's any disagreement about the proposed findings, then what I want you to do is a red line, blue line findings, which I think we talked about that before when it came to the judgment. But if you just to kind of remind you, we don't have any findings. We haven't already done this, right?
Correct.
Okay.
Well, I think pre-trial we filed some proposed findings,
Right.
but we haven't done anything post-judgment.
So everything you agree to, have it in black. Everything that the plaintiff wants be in blue. Everything the defendant wants will be in red. Submit it to me as a Word document, and I'll do the findings and conclusions. Any questions?
Nope. Works for us.
And try to get that to me by Friday. By Friday at 9 o'clock. Email it to Rhonda at 9 in the morning to Rhonda and e-file it as well.
Okay.
Will do.
All right, guys, any questions?
No.
Nope.
All right, you guys be safe.
Yeah, you too. Thanks. Good to see you. Happy New Year.
Yeah, you too. Talk to you guys later. Bye-bye.
Take care. See you, Scott.
Thank
See
you,
you,
Judge.
Manny.